Thanks so much for that introduction, and I really appreciate the opportunity, the invitation to be here at the Shaftesbury to talk about some of the themes from my book on state constitutions, and it really is an opportune time. As I say, Don said, we scheduled this a while ago, and of course just last week a voter ID amendment is filed in the state legislature. There are other constitutional amendments that are under discussion. And so what I thought I would do today is to kind of set up some context about state constitutions and state constitutional amendments. And let's start from the beginning. Let's start comparing state constitutional amendments with amendments to the U.S. Constitution. Amendments to the U.S. Constitution are rare events. Only 27 of them total. And even that overstates things because a full 10 of those amendments were adopted in the first 2 years of the Bill of Rights. So really, we're talking about only 17 amendments to the U.S. Constitution in some 225 years. That's the situation at the federal level. But state constitutions are a very different situation. Now, the 50 states vary. They vary in so many ways. Well, they vary in this way as well. But let's just consider North Carolina. North Carolina's most recent constitution is the 1971 Constitution, and that's been amended 37 times. If we do the math, that's slightly under one amendment per year on average, if we do the math. How's that compare? Well, let's go to our neighbor, Virginia. I grew up in Virginia, so I'll compare it to Virginia. Virginia also has a 1971 Constitution, and they've amended theirs slightly more than one amendment per year on average. North Carolina and Virginia are in the broad middle of the pack when it comes to state constitutional amendments. There are some states that are even more frequent. Alabama amends its state constitution on average 8 times per year. They take I could say Alabama's unique in that way, but Louisiana amends its constitution 4 times a year on average. So that'd be one end of the spectrum. As I say, North Carolina's in the middle. You go to the other end of the spectrum. Vermont is the least frequently amended state constitution, but even Vermont's constitution is amended about once every 4 years. My point in stressing that is all 50 states amend their constitutions more frequently than the U.S. Constitution is amended. Well, this regularity of state constitutional amendments invites several questions that I explore in my recent book and that I want to take up today. 3 questions in particular. First question, one, why are state constitutions amended as often as they are? Second question, what are they doing with these amendments? What are the subject matter? Are there patterns that can be identified in the subject matter of state constitutional amendments? And the third question is, what should we make of this regular resort to amendments in the state level? Is this something to react negatively and say, oh, that's regrettable that it happens as often as it does? Or is it something to be encouraged and welcomed? Oh, it's a good thing that this happens so often. So let me take up each of these 3 points in turn. And let me start with the first of these, this explanation question. If we're going to turn to explain why state constitutions are amended as often as they are, and why they're amended more often than the U.S. Constitution, our starting point would have to be with the differences in the rules. How easy or hard is it to amend state constitutions as compared to the federal Constitution? And then a second point is there's simply a different culture or understanding or view of a Constitution that accepts regular amendment and at the U.S. level doesn't. Let me elaborate on both those points. Let's look at the path that a U.S. constitutional amendment has to face before it gets adopted. 2 steps. One is the dominant step. 2/3 of both houses of Congress have to approve an amendment. 33 amendments have passed that first hurdle. Then we come to the second hurdle, ratification by 3/4 of the states. 6 amendments made it through the first hurdle and failed to get it through the second hurdle. We could talk more about that. Perhaps one of the ones that's most interesting in this regard is the Equal Rights Amendment, which has come up for recent discussion, and we could certainly talk about that. But that's one of 6 amendments that got through Congress, but it did get ratified by enough states. But that means 27 amendments made it through both hurdles. Those are pretty high hurdles. 2/3 of both houses of Congress, and then 3/4 of the states. That's a high barrier. How about, though, the rules for amending state constitutions? Again, each state has its own rules. There's no one kind of set of rules that's going to be uniform. But let's again start with North Carolina. which is, again, very much in the middle of the pack in terms of the 50 states. Step one for North Carolina, amendments need the support of 3/5 of both houses of the state legislature. Step two, get the ratification of a majority of voters. Those are the North Carolina rules for how you amend the state constitution. Well, how's this fair in terms of looking around the 50 states? Let's take up step one, the legislative approval rule. North Carolina's 3/5 rule is really in the average of the pack. It's lower than the 2/3 rule in some states. West Virginia, it takes a 2/3 vote of the state legislature to put an amendment on the ballot. But North Carolina's 3/5 rule is actually slightly more rigorous than the rule in place in Arkansas, where it just takes a majority vote of the legislature to put an amendment on the ballot. So again, the theme here is North Carolina is roughly in the middle of the pack. The one other thing I'll say here is North Carolina only requires the legislature to approve an amendment in a single session. Virginia, they require an amendment to go through two sessions separated by an election. Again, so for North Carolina, really middle of the road there. How about step two, voter ratification? North Carolina, in requiring a majority vote of the people to ratify amendments, is following the broad majority of states. That's the dominant way that you get amendments approved in states around the country. Just get a majority vote of the people. 8 states go a little higher. In Florida, they say, we want 60% of the voters to approve an amendment. Colorado a few years ago, they said, well, how about 55% in that sense? But with these exceptions, there's 8 exceptions, but other than that, North Carolina is well within the range of other states. All it takes is a majority vote of the people. So what I've just set out here, these legislature-driven amendments, are the dominant way that state constitutions are amended around the country. But it's not the only way that you can find around the country. North Carolina doesn't have this approach, but 18 states allow for citizen-initiated constitutional amendments. Most of these states are out west: California, Arizona, Colorado. Legislature's out of the picture for this process. The people can just put an amendment on the ballot and approve it. The legislature doesn't have a role in that sense. Florida is unique. Florida says that every 20 years, a commission automatically comes into being, a constitutional revision commission, and they can craft amendments and put them on the ballot directly, again, without any role for the legislature. It just so happens that every 20-year calendar came up this year. And so the Florida Constitutional Revision Commission just put a package of 8 amendments on this year's ballot in that sense. No other state has that ability, but in Florida they do. And then one other thing I'll mention here with these kind of unusual procedures that aren't present in North Carolina but are present in some other states. 14 states say that every so often there's required to be presented to the people a question. Do you want to call a convention to consider amendments to your state constitution? Usually it happens about every 20 years. So New York, they had a vote on that just last November. They could say, do we want to call a constitutional convention? They could propose amendments to the New York Constitution. They defeated it overwhelmingly. Hawaiians will vote this November on such a vote in that sense. Well, my point is here, part of the reason for the regular resort to state constitutional amendments at the state level is simply it's easier to change state constitutions, and there's a greater flexibility of rules for doing so that are not found at the federal level. That's part of the reason, but it's not the only reason. And let me put it this way. North Carolina, the Constitution is actually easier to amend than the Louisiana Constitution. And yet the Louisiana Constitution is changed 4 times as often as the North Carolina Constitution. So it's not only about the rules, it's also about the culture, the expectation. What is appropriate behavior and what's not appropriate behavior? There are simply different expectations about the propriety of regularly resorting to constitutional amendments. At the federal level, for instance, when somebody proposes an amendment to the U.S. Constitution, the critique is often heard and often turns out to be persuasive. People say, you shouldn't tinker with the Constitution. Don't just put something in the U.S. Constitution that way. And that often is very persuasive. People say, that's right, we shouldn't do that to the U.S. Constitution. And there's even some states where when someone proposes amending the state constitution, if you were in Vermont or Connecticut, for instance, and if all of a sudden you were to see 9 or 10 amendments on the ballot, there'd be some discomfort, some surprise. I said, well, we don't do that here. That's not our cultural expectation. If you're in Louisiana or Texas or California or Colorado and you see 9 or 10 amendments on the ballot each year, people don't bat an eye. They say, yeah, that's kind of what we do here in that way. And so, again, North Carolina, I would say, would be in the broad middle of the pack. So my answer to my first question, why are state constitutions adopted, changed as often as they are? Part of it is because the rules allow for regular amendment, and part of it's just a cultural expectation. When I say culture, a constitutional culture, what you see as proper in that sense. Well, let me turn to my second topic here. If state constitutions are amended on a regular basis, what types of changes are made through the amendment process? Are there patterns? What are people doing when they amend these state constitutions as often as they do? And let me turn, I think it is possible to identify some patterns, and let me set out three kind of broad types of topics that you see through state constitutional amendments. A first broad group of amendments is directed to constraining the legislature from doing things in areas where the legislature has been seen as not as disciplined, not as responsible as it could be. And so the idea here is, you've shown yourself maybe not to be best at this, we're going to limit you in this regard. A lot of this has to do with money, with budgeting, with taxing, with spending, with borrowing. Let me give some examples. 36 states have amended their state constitutions to require a balanced budget. No balanced budget amendment in the US Constitution. 36 states have said, you know, if we don't have a balanced budget amendment here, North Carolina, I should say, adopted a balanced budget amendment in 1977 in that sense. Why did these get passed? Because people say if we don't have a constitutional constraint, legislatures, they might balance the budget in some years, but maybe some years they'll say, oh, we can't quite do that. We're going to make you do that in that sense. I should say Indiana has on the ballot this year, they would become the 37th state with a state balanced budget amendment. It's been proposed in there. Then you have amendments, limiting borrowing. Many of these provisions date to the mid-1800s. Early 1800s, a lot of state legislatures, they spent a lot of money building roads, building canals, helping to build railroads, and then all of a sudden there was an economic crash in the 1830s. And all this money that had been borrowed to spend for this, you had a fair number of states that actually defaulted on their debt payments. They simply said, we can't pay our debt payments anymore. In response, a lot of state constitutional amendments were adopted saying, there's a limit to how much you can borrow. Or they say, if you are going to borrow money, you have to get the approval of the people before you do so, to constrain the legislatures from getting involved in some of the things that they were seen as having gotten involved in irresponsibly. Of course, once you get these state constitutional borrowing limitations in the Constitution, legislators then want to get around that, and sometimes they'll say, well, we think we should need to borrow money for this. And so that leads to a whole other set of constitutional amendments that ease the borrowing rules. If we look over North Carolina's amendments, you say, well, what's in these 36 amendments that North Carolina's had since the 1971 Constitution? No category is more prominent than efforts to allow borrowing without the approval of the people as a way of getting around a long-standing provision in the North Carolina Constitution. They say, well, how about, could you allow revenue bonds for these kinds of things? Or could you allow tax increment financing, to get into the weeds of some of these matters? So that's a subject of constitutional amendments. First of all, limiting borrowing, but then turning around and allowing borrowing in greater number of cases. Of course, sometimes state legislatures evade these provisions without amending the Constitution. They come up with other ways of borrowing, but a lot of times they do go, let's go the constitutional amendment route. Other amendments around the country, they'll limit taxes. The concern is that if left to their own devices, legislators can't be fully trusted with the taxing power. And so they will say in some states, they'll amend the Constitution, let's require a supermajority of the legislature to increase taxes. Or let's require the people to approve in a referendum any increase in taxes. Or some state constitutional amendments will just forbid certain taxes altogether or put limits on the tax rate. So, for instance, North Carolina, since the 1920s, has had that its individual income tax rate, they first of all had a cap at 6%. Then they amended the Constitution. They say, well, the maximum individual income tax rate could be 10%. And that's where it currently stands in the North Carolina Constitution. The Constitution of North Carolina says the state income tax rate cannot exceed 10%. Well, there's an amendment that's circulating in the legislature that would reduce that 10% to 5.5%. And say that would be the maximum allowable income tax rate. If North Carolina were to approve such an amendment, it would follow closely on Georgia, which in 2014 passed a constitutional amendment capping the income tax rate at 6%. So you can see very similar. North Carolina would cap it at 5.5%. Georgia, 4 years ago, capped it at 6%. Also in this category of, I think, amendments that constrain the legislature are amendments that seek to limit how state officials spend the money that they get through taxes. Let me give some examples. Sometimes states will say, we're going to start a lottery and all of that money is going to schools. Or they'll raise the gas tax and they'll say, and every bit of this money will go to road building. Won't be used for anything else. Well, as a way of making sure that legislators actually honor those commitments, you will oftentimes have state constitutional amendments passed that say explicitly, any gas tax revenue will be spent for no other purpose than road building, or any lottery revenue will be spent for no other purpose than education. California just approved one of these lockbox amendments just 6 days ago. California is voting on constitutional amendments, and they said any gas tax revenue in California has to be spent on road building. 5 other states will be voting on these so-called lockbox amendments this November in that way. Let me, one final one of these legislature constraining amendments, and this doesn't apply so much to North Carolina, but has a recent occurrence. A lot of amendments in other states deal with gambling. Dating back to the mid-1800s, lotteries were all the rage in the early 1800s. And at that point, people took a look and they said, lotteries aren't good for the people. I mean, we all can agree that lotteries are not something that you ought to be spending your time on. And yet legislators, they're always tempted to resort to a lottery. It's easier to do that than raising taxes. And so a broad movement swept across the country in the 1800s to amend the state constitution and prohibit lotteries or any other form of gaming. Historically, from the mid-1890s to the 1960s, this movement was so strong, there were no legal lotteries in the states in the United States for a whole 6-decade period, from the 1890s to the 1960s. And then New Hampshire kicked off the recent lottery craze in 1964, and now 44 states have lotteries. My point, though, is that a lot of states, North Carolina never got one of these anti-lottery provisions, but a lot of states did. And so if you're one of these other states that does have an anti-lottery or gambling provision in the state constitution, you then have to amend the state constitution to overcome that constraint. And so, for instance, a few weeks ago, the U.S. Supreme Court said, states, you can now legalize sports betting if you want. It's up to you. If North Carolina wanted to do that, a legislature could pass a bill tomorrow and sports betting could be permitted. But other states, they would actually have to first amend their state constitution because their state constitution prohibits how much they can do so. So that's one whole set of amendments. People say, what do these amendments do? A lot of the amendments constrain the legislature. A second set of amendments. They're directed not at the legislature, they're really directed at the judges. And they're directed at judges in 2 ways. One, sometimes they achieve goals that judges aren't willing to achieve. And the state constitutional amendment says, we'll handle this on our own. If the judges don't get us there, we'll get it there this way. And then other amendments are directed at judges to overturn things that the judges have done and say, I'm sorry, judges, we'll have the final word on this in that sense, as the people in that sense. What are some examples of these amendments around the country and in North Carolina that could be said to be directed at judges? Well, victim rights amendments are a leading example. There's no victims' rights amendment to the U.S. Constitution. And yet 35 states, including North Carolina, have amended their state constitution to protect the rights of crime victims. There was no waiting around for judges to say, can you read this by interpretation? Can you protect crime victims' rights? The state of North Carolina in 1996, they put on the ballot and the people approved. The victims' rights are protected in the following way. Now, other states are saying, well, that was a good try in that first round. As I say, 35 states have adopted these amendments since the 1980s. But now some states are coming back and saying, we actually want to tighten up and provide increased protection for victims' rights, what's called so-called Marsies Law amendments. And that way they tighten the protection. It turns out there will be 5 amendments on the ballot around the country this year that will deal with victims' rights. North Carolina could be one of them. We'll see. If it did, it would become the 6th state. Hunting and fishing rights generate a lot of state constitutional amendment activity. Since the mid-1990s, 20 states have adopted hunting and fishing rights amendments to their state constitutions. North Carolina has in the hopper a hunting and fishing rights provision. If it were to do so, it would become the 22nd state. The most recent ones Indiana and Kansas just approved hunting and fishing rights in 2016. North Carolina could join the group. And then you also have state constitutional amendments that protect property rights and limit use of the eminent domain power. Folks might remember the U.S. Supreme Court in a 2005 decision was asked, is there a federal constitutional right that will prohibit the government from coming and saying, it's a nice house you have there, but it would look even better if there was a shopping mall on it, in that sense. We need your house, we'll pay you what it's worth, but be better with a shopping mall, in that sense. U.S. Supreme Court said, we hear you, but we're not going to see a federal constitutional right to protect you from that. It was a 5-4 decision. That's not the end of the line. A dozen states have passed state constitutional amendments that explicitly say you cannot use the eminent domain power for economic development purposes. That's out of line. Again, North Carolina could well add to this group and pass a provision tightening eminent domain protections. Just a few more examples of these rights-defining amendments that I talked about. New Hampshire voters will be voting this November whether to approve a state constitutional privacy amendment. There's no explicit privacy amendment in the U.S. Constitution. But 10 states have amended their state constitutions to say, we want to explicitly protect the right to privacy. New Hampshire would become the 11th state if that amendment is approved. And then, Delaware legislature just last week took the first step towards approving a state equal rights amendment. There might not be a federal equal rights amendment. That might have stalled. But 22 states have said, we're going to provide in our own state an equal rights amendment. In that way, as I say, Delaware might join the group. Well, these amendments that I've just been discussing, they're directed to the courts, but really directed to the courts to saying, courts, you're not acting aggressively enough in these areas. We want to protect these matters. But then there's another set of cases where they're directed to the courts. Not so much, the purpose here is to prevent courts from issuing certain decisions or even overturn decisions that courts have issued. The 31 same-sex marriage ban amendments that were adopted between 1998 and 2012 were adopted for this purpose. That is, in California, the state Supreme Court had required under the state constitution that same-sex marriage be legalized. And the people of the state, 6 months later, turned around and amended the state constitution and said, we override your decision. No, same-sex marriage shall not be legalized in California. And that was the final word in California, at least for that. The other 30 states who passed same-sex marriage ban amendments, North Carolina was the most recent state to do so, the last state to do so in 2012. It's not that the state court had required legalization of same-sex marriage in those states, but the purpose of the amendment was to preempt the state court from issuing a decision of the kind that's been seen in California. I should stress something here. It's very important to stress. I'm going to stress it again in a few minutes. Passing a state constitutional amendment of this kind can constrain state judges. It has no bearing on federal judges. Put another way, from a federal judge that would be considering whether same-sex marriage should be legalized or not, it doesn't matter all to them whether or not a same-sex marriage ban stands on a statutory or a constitutional provision. If the federal court reads something, that overrides anything. And so when the U.S. Supreme Court recognized the right to same-sex marriage in 2015, this overturned all state laws and all state constitutional provisions to the contrary. I'll mention just a few other of these amendments that are meant to prevent or overturn court decisions. Arkansas has 2 amendments of this kind on the ballot just this year. One amendment in Arkansas would authorize tort reform legislation. The legislature of Arkansas tried to pass tort reform measure. It limits how much damages can be given out in court suits. And the state Supreme Court of Arkansas said, I'm sorry, that violates the Arkansas Constitution. That tort reform measure is struck down. So the legislature has placed on the ballot, no, tort reform measures shall be allowable under the Arkansas Constitution. If it's approved, that would trump the state court decision. And then the other Arkansas amendment, this has current relevance here, Arkansas has a voter ID amendment on this year's ballot with similar motivations and with similar origins. Arkansas passed a voter ID law a few years back, only to see a state court strike it down as inconsistent with the Arkansas Constitution. As a way of overcoming that state court decision, the Arkansas legislature has crafted an amendment making clear that a voter ID requirement is okay under the state constitution. A similar voter ID amendment was on the ballot in Missouri 2 years ago for similar reasons, and that also passed. Of course, North Carolina legislators just filed a similar voter ID amendment of the kind that Missouri passed 2 years ago and that Arkansas will vote on this year. Again, I want to go back to a point I made earlier, just to be clear about this. Such an amendment would have no effect on federal judges who might consider the legitimacy of a North Carolina voter ID law. That, it doesn't matter. You could pass that on statutory grounds. You could pass it on a constitutional amendment. It simply has no bearing for the federal courts. The purpose of a voter ID constitutional amendment in North Carolina, much like in Missouri and Arkansas, would be to insulate a voter ID requirement from invalidation from the state courts in North Carolina. I'm not sure how much of this has been picked up on the coverage of this in the last few years, but that would be the reason for having a voter ID as a state constitutional amendment. Folks might recall, this has taken us back to 2016, North Carolina's original voter ID law was subject to federal court challenges and state court challenges. The law eventually failed in federal court, but there would have been a state court proceeding that would have been going through even if that federal court decision had gone another way. And at the time, the challengers on the state court level to North Carolina's voter ID law from 2013 said you would have to amend the Constitution to add this as a requirement before it would be legitimate. So one could view the voter ID amendment that's just been filed in the North Carolina legislature as a response to that invitation from the challengers to say, okay, we'll put it in the Constitution, and that way a state court could not strike it down. Well, let me very briefly, there's a final category of amendments. They haven't been seen much in North Carolina, but they're prominent in other states. And let me just spend a few moments on this third category of amendments. These are amendments that adopt policy or institutional reforms that are blocked in the legislature or are seen as not secure in the legislature. Oftentimes, these sorts of amendments, these policy or institutional reforms, they're enacted in the 18 states with a constitutional initiative process. By very nature, the legislature is not excited about them, so they have to bypass the legislature. This is how you oftentimes get independent redistricting commissions, is through constitutional amendments proposed through the citizen initiative process. That's how California and Arizona got their independent redistricting commissions. Or that somehow, some of the way that you've got marijuana legalization measures in Colorado, that was actually passed as a state constitutional amendment. Or that some of the ways that you get the minimum wage increase measures is passed through state constitutional amendments. Why would these be passed as state constitutional amendments in some of these states? Because people who are proposing marijuana legalization or proposing a minimum wage say, if we just put this on a statutory ground, the legislature, they might come gut it next year, and then what would we be left with? But if we put it in the Constitution, that renders it secure. As I say, North Carolina just doesn't really have many of these amendments of this kind. And so because North Carolina doesn't have a citizen initiative process, so when people ask, sometimes I say, why doesn't North Carolina have a independent redistricting commission? Why doesn't North Carolina have marijuana legalization? Why doesn't North Carolina have a higher minimum wage? A lot of it is the absence of the initiative process that's found in a number of these other states. Well, having set out the reasons why state constitutional amendments are so prominent, and then looking at the types of amendments that are adopted, let me turn briefly to a final question. I raised this at the beginning. How should we react to this regular resort to amendment? Is this something to be regretted and discouraged? Or is it something to be kind of welcomed and encouraged? The conventional view, which I argue against in my book and which I'll push back against here today, the conventional view sides with the first of these positions, the regret and discouragement reaction, and not the welcome and encourage reaction. According to this conventional view, what I've just described in my talk so far today is not something that's a pretty picture. It's something that's to be regretted. It's, after all, when constitutions are amended on a regular basis, this detracts from the purpose of a constitution. Constitutions should be short. They should be focused on general principles. They should not be long and detailed and replete with all kinds of provisions that are better found in statutes. According to this conventional view, when constitutions are amended regularly, this takes away from the respect that people have for the Constitution, leads to inclusion of all sorts of material not fit for a constitution. This conventional view certainly describes the attitude that's in place at the federal level for the U.S. Constitution. And in fact, it has a most distinguished lineage It's most associated with James Madison, who wrote in the Federalist Papers. He talked about the benefits of having veneration for a constitution that's long enduring and is not lightly changed. But I would conclude, and I would argue today, this is not the only legitimate view of the purpose of a constitution, of how often a constitution should change, and what should belong in a constitution. In many ways, and I can claim an equally distinguished lineage here of Thomas Jefferson, in many ways state constitutions follow the approach not favored by James Madison, but by approach favored by Thomas Jefferson, who argued at some length with Madison. They were going back and forth in letters. It was fascinating to read these letters. And Madison would make a pitch. He said, I think the U.S. Constitution should be hard to change. And Jefferson pushed back. He said, I disagree. Jefferson said, I think every generation should have a chance to revisit its Constitution. I think there ought to be a regular avenue for changing the federal Constitution. Jefferson lost out in that debate with Madison. The federal Constitution is a Madisonian reflection. But Jefferson's vision prevailed in the 50 state constitutions. According to this Jeffersonian view, constitutions are respected not because they're old and their text relatively untouched, but rather because when changes are made in the understanding of constitutional provisions, these changes are made through formal amendment processes that clearly signal that a constitutional change is being made and that give the people a chance to formally approve or reject that change. That would be the Jeffersonian vision. This might be seen, then, this Jeffersonian idea, as one key benefit of the regular resort to passing constitutional amendments in the states. For instance, rather than waiting for judges to bring about changes in victims' rights or other rights through interpretation, far better just to have these changes recorded in constitutional amendments, that the people have a chance to publicly say, yes, we sign off on this. That could be said to be one benefit, one thing that could be good about the picture I've described today. The final benefit that I'll turn to of regular resorting to constitutional amendments at the state level is that this can be seen as helping to correct for problems in governing that would otherwise be tough to correct or might even go uncorrected altogether. One might highlight here the use of amendments to create independent redistricting commissions in several states, or the reliance on amendments to require legislators to honor commitments that gas tax revenue will only be spent on transportation and lottery revenue only spent on schools. Or one might highlight amendments that correct and therefore overturn judges in cases where voters and legislators find the judge's interpretation of the Constitution to be suspect and in need of correction. I'll close here. My overall point has been to call attention to the regular passage of amendments in the states, try to explain that regular passage, set out some of the patterns of what is passed, and then to make a brief case, I could do a longer case, for why this is actually something to be welcomed. And the overall takeoff point is that we're about to embark in the next few weeks in North Carolina on some debates in the legislature about putting as many as a half dozen, perhaps, amendments on the ballot in November. And then we're also about to embark for the next several months in a public debate on these amendments. Not only the substance of the amendments, but whether or not they belong in the North Carolina State Constitution. And how perhaps these remarks here today can help put in context and provide some perspective and illumination on those debates that we'll be about to embark on. Thanks.